All right, welcome everybody. Thank you for joining today's presentation. It looks like we've still got a few people jumping in. Excited about this one today. I looked at our report on who is registered, and I see lots of clients and friends out there. So it's good to sort of see everyone virtually and hope that you'll participate and weigh in today through the Q&A or the chat box if you've got questions or just to say hey. Today we're going to be talking about employment contracts in South Carolina, but before we do, just a couple of things for those of you who may be new to our employment team presentations. Got a little bit about our law firm up here on this slide. If you're attending this webinar, you're probably already a subscriber to our blog. And if you are, great, but please pass along to your colleagues and friends. We try to keep our clients and others up to date with all of the latest and greatest with employment law and legislation and recent cases and things like that. So that's the best place to keep up with us and see what we've got coming down the pipe as well. You can submit questions through the Q&A chat in this platform. I'll definitely have some time at the end of this presentation. I don't think this presentation will be an hour long for us to sort of talk through some questions, but feel free to go ahead and type them in to the chat feature as we go along. I know a lot of times as they come into your head, if you don't write them down, you'll forget about them. So it won't bother me, and I might, if I see it pop up while I'm presenting, go ahead and answer that. And just a quick legal disclaimer that I'm not providing fact-specific advice to any of you on specific situations you've got going on. Currently, it's more informational purposes only. The course has been submitted for credits, and we'll share the slides with you after the presentation. So a little bit about what we're going to talk about today. Employment contracts are sort of a pretty bedrock principle of what we do, and it's not something that we sort of talk about in our webinars. I think primarily because we just sort of assume that most organizations sort of understand this or have in place what they need as far as contracts or lack thereof. But it's one of the first questions that I always ask clients when they call, particularly when a client calls telling me that that they need to fire somebody. Typically, one of the first questions I ask is whether or not the employee has an employment contract, because everything in the employment relationship kind of stems from what do you have written down concerning how long this person is to be employed, circumstances for firing him or her, and things like that. So it's a really important topic. The bullet points here are just some of the things that we'll hit on today. So we'll jump right into it here. And I think the first thing to keep in mind is that the employment relationship is, by its very nature, a contractual relationship. Whether or not you have an actual written contract with a worker, you've got a contractual relationship with that worker. One part, even if it's at will and there's nothing in writing, the employment relationship is basically one person, the employee, agreeing to provide services, and that person receiving pay for those services. And so that's a contract. And this is true whether you hire the person as a W-2 employee or as an independent contractor. You're agreeing to pay someone for performing services, and that right there is a contract. Now, at-will employment is probably, one of the most fundamental legal things that we have in regards to the employment relationship in South Carolina. And all at-will employment means is that the presumption in South Carolina is that the employment contract is of an indefinite term. And it's a presumption unless the employee can prove otherwise. So unless you agree with one of your workers that, hey, we're going to employ you for 2 years, or we're going to keep you employed unless you screw up, or we're going to keep you employed unless you do this or that. The presumption is that every employee in South Carolina, when they are hired as an at-will employee. And really what that means is that you can fire that person, or that person can quit without notice, without incurring any contractual liability. In other words, if you have an employee that is supposed to show up for work tomorrow at 9 o'clock and they don't show up and never call you and just ghost you and never return to work, under that at-will employment doctrine, that employee has the right to do that without incurring any contractual liability. And you wouldn't be able to file a lawsuit in court saying, hey, judge, this employee quit without notice. They don't have to provide any notice. You can't say, judge, this person was, we expected this person to work for us for 3 years. We invested a lot in this person, et cetera, et cetera. If it's an at-will employment relationship, no notice is required. And same goes for the employee. If an employee is fired one day, he or she can't go to a judge and say, I expected that I was going to have this job for 5 years time. And, my whole career is ruined now. Because of the doctrine of at-will employment, there's no contractual liability for being fired or quitting. So one sort of thing that, I always have clients call me and, just think that terminating, because of at-will employment, terminating somebody is always straightforward, and that, no organization can ever be sued by an at-will employee because of his or her termination. And that's not what at-will employment means. At-will employment just means that from a contract standpoint, the employee doesn't have any guaranteed term of employment. And so the employee could find other reasons to sue you for their termination that have nothing to do with an employment contract. For instance, the employee can, I'm bad with my Roman numerals, that should say Title VII, not Title 12. An employee could sue you for discrimination if you're subject to state and federal anti-discrimination laws. An employee could sue you for workers' comp retaliation if they claim that they were fired because they got injured on the job. And then there's other things, violation of the Family and Medical Leave Act, Americans with Disabilities Act. We have something in South Carolina called termination and violation of public policy. So there's all these things that in the employment relationship that are governed by these laws that most all of you would be familiar with, that sort of have nothing to do with contractual terms or contractual liability. And so just keep that in mind with at-will employment when it comes to contracts. Doesn't mean that, the doctrine of at-will employment in South Carolina does not mean that an employee can never sue his or her employer, as I'm sure most of you that have had to deal with employment lawsuits are well aware. One other thing with at-will employment that I think is sometimes missed is that an employee can still be considered at will even if you write up a formal contract with the employee. You have to be pretty careful not to screw up at-will employment, but if it's drafted properly, of course, I advise that to be done with, in conjunction with legal counsel. Then you can write up a formal contract, an employment contract with an employee that still maintains the at-will employment relationship. And a few things to keep in mind with that. You have to make sure that there's the at-will disclaimer that South Carolina law, state law provides, which has to be on the front page of the contract, in bold underline, which is basically a clear notice, South Carolina public policy, clear notice to the employee that, hey, this is an employment contract you're signing with us, but we're not guaranteeing you that we're keeping you employed for a certain amount of time. This is an at-will employment relationship, and you need to understand that it's at will. You've got to make sure that even if you've got the disclaimer, you can't disclaim at-will employment and then turn around and say, we executed this contract on September 29th, 2022, and it runs until September 29th, 2024. That's not an at-will agreement. That's a term agreement. That's a contractual term saying you are going to employ that person for 2 years. If you're not careful, what can happen is if you terminate somebody before the end of that 2 years, you run the risk of the employee being able to go to court and saying, they promised me they were going to employ me for 2 years under this contract. They terminated me early. Under contract law, I'm entitled to get pay through the rest of the end of the term of the contract. And most employment lawyers have seen this very often. I've seen a lot of instances of this with foreign companies who are new to doing business in South Carolina. The laws concerning at-will employment and employment contracts are very different in Europe and Asia and different parts of the world. Maybe they hire somebody in the United States, they're just getting up and running, and they're using contracts that you might have seen in Europe or somewhere else that are for employment terms, and they don't understand that in the US, if you terminate somebody early from one of those term contracts, you could be on the hook for paying them out through the entire term of the contract. The other thing you don't want to do in an at-will employment contract is get into this whole murky world of what's a for-cause termination and what's a no-cause termination. Because really, if you start to talk about reasons why the company can or cannot fire somebody, that is inconsistent with at-will employment. That's not really an at-will employment agreement. If you start to talk about, well, we can terminate the agreement if you commit a crime or you fail to meet performance expectations or something like that, you're changing at-will employment. You're stating in the contract, these are the reasons that we're allowed to fire somebody. And if we don't follow that, then we could be liable for breach of contract. And these cause, no cause provisions are very common and in some circumstances necessary, in some circumstances very useful for an organization, but they can lead to lots of litigation, of somebody saying, well, you really didn't have cause to terminate me. And I disagree with your determination that there was cause. So I think one question probably many of you have is, if we've got at-will employees, most of your at-will employees I'm sure don't have a written contract. And so you're probably wondering, why would we do that? Why would we actually even get into this murky world of and potentially mess up at will employment by putting something in writing in a formal agreement? There are advantages for the company. The second bullet point here, it certainly it would allow you to do things like put in restrictive covenants, which we'll talk about in a little bit, like non-compete, non-solicitation. It could allow you to sort of more carefully outline what a person's job responsibilities are. You might have confidentiality provisions in there. There's a lot of reasons why you may want an employment contract. For some industries, it's more standard than others. So you may be out there recruiting into a certain market, and it's the expectation of the applicants for employment that they are going to have an employment contract. We got a question from one of the attendees today about repayment agreements, things like, what if we're going to provide moving expenses, relocation expenses for an employee, or what if we're going to provide tuition reimbursement? There are things like that you may say, hey, we need an agreement anyway. We got to put in writing some responsibilities about, okay, we're going to pay $10,000 from this person for this person to relocate from California to South Carolina. We need something in place. If the person turns around and leaves us, they've got to pay that back. Well, you're going to need to write up a contract for that anyway. So you could put that, restrictive covenants, all this stuff in kind of one employment agreement and deal with all of that and still have them be at will. So there are circumstances, which is why I'm going through this. There are circumstances where it would make sense even for an at will employee to have a contract. Another point about at will employment is that you want to make sure, just like in a written contract, all your other written employment human resource documentation has appropriate disclaimers so that you do not accidentally screw up at will employment. As I said at the beginning, at will employment is a presumption. Employees can overcome that presumption by saying, hey, actually, my boss promised me that he would keep me employed until the end of the year because of this or that. And here's an email where he or she told me that they would keep me employed until the end of the year. And in order to fight against, and there's a lot of cases in South Carolina dealing with this, in order to sort of fight against those types of claims, you've got to make sure that your employee handbook, an offer letter, which we'll talk about in a minute, and any other human resource policies that you have include appropriate disclaimers. So for policies, if you roll out a sales commission plan or a bonus plan or any kind of HR documentation like that, I always just to be safe want to put that at will disclaimer on the front page of everything, just so the employee knows. I mean, if you roll out a commission plan for 2023 and say, hey, if you do this, you're going to get this amount of commissions in 2023. You don't want an employee to be able to say, well, when I got that, I thought that meant that I was going to be there in 2023. And so if you've got appropriate at will disclaimers and all those documentation, that's an easy way to say, no, you could not have thought that, because we made it very, very clear in bold underline on the front page of the document that you were an at will employee. So just make sure that handbook provisions, there's cases on handbook provisions like disciplinary policies and progressive discipline, and you've got first step is typically to write somebody up before they're going to be fired, or you're a municipality and you've got a grievance procedure within your handbook or something like that. Those types of policies within a handbook can complicate at will employment. So it's very important that you have those disclaimers in all of your documentation. So I see we've got a question in the chat about offer letters, and it was very, very good timing because that's what we're about to talk about next. And I'm sort of moving on a little bit from the doctrine of at will employment. At will employment is very, very important. So if you've got questions about the at will employment doctrine, feel free to put those in the Q&A as well. I would say for most of your at-will employees in South Carolina, they're probably not going to have a formal written employment agreement like I was talking about. What they are probably the only thing they're going to have that sort of comes close to looking like an employment agreement is an offer letter. An offer letter, most of my clients use offer letters for at-will employees. It's basically a way to notify somebody, hey, this is what you're going to be paid. This is what your job responsibilities are. This is when you got to show up to work every day. This is who you're reporting to, a lot of the basic sort of new hire information that you provide to somebody. That you would do in writing, and have the candidate sign the offer letter as well, saying that they've accepted these things. There's you see this terms of employment notice here. South Carolina does have a statute. It is SC code AN 411030A, and that's part of the South Carolina Wage Payment Act. And that states that every company in South Carolina is required to notify each employee in writing at the time of hiring of the normal hours and wages agreed upon, the time and place of payment, and the deductions which will be made from wages, including payments to insurance programs. So by South Carolina law, the only thing that you are required to have in writing with a new employee is this information about how and when they're going to be paid and what deductions are going to be taken out of their pay. The South Carolina Department of Labor has put this into a nice little form called that you see on the screen, called Terms of Employment Notice. You do not have to use this exact form. Most of my clients don't use this form, but it's not a bad idea if you just wanted to use this form. We've heard from Department of Labor investigators that if they see this form, they kind of check the box because they know that this form's got the required information on it. If you're using your own form that you created within your organization, obviously they're going to have to look closer at the type of information that's in there to make sure that you're covering all of your bases. And so we can just kind of go through this. It's got full-time, part-time, number or range of hours per week, if it's supposed to be, 9 to 5 or whatever. The person's wages, salary, commission, when payday is, where the place of payment, time of payment is, and deductions that are going to be made from your pay, including insurance deductions. So that top part of the form is what's mandatory under South Carolina law. And you'll see in the sort of fine print there, any changes in these terms shall be made in writing at least 7 calendar days before they become effective. So those of you who've talked with Chris or with me or any other member of our team about making pay changes for employees' pay, you've probably heard us tell you that you've got to notify the employee at least 7 days in writing before any change is made to their pay, and that's where this comes from. You'll see this form also has additional terms down there, vacation policy, paid holidays, sick leave. Those are things that you typically see in an offer letter as well. Not necessarily mandated by law, but it is something that you would typically see. There is a line there for other for you to enter in other information there. But this form is a little bit rigid, which is why most of my clients don't use it. There's a lot of other things that you probably want to include in an offer letter, which we'll talk about in a minute. And there's probably, if, for instance, on number 2, rate of pay, you see the commission percentage. If you're paying an employee commissions, you want to provide them a lot of information about how that commission plan works. You probably have an entire commission plan, but certainly you don't just want to say rate of pay 20% commissions. Well, 20% commissions of what? And so an offer letter a lot of times will include a whole paragraph or two on what the terms and conditions of commissions are. So I say that just to say that using this form is a little rigid for a lot of circumstances and for a lot of organizations. One thing you could think about doing is including this form along with whatever your organization's actual offer letter is, and use this form in addition to that offer letter. See some questions here. So a couple of good questions. Keith says that this form doesn't seem to reflect employment at will. Should it be noted somewhere on the form if used? That's a fantastic question. 100%. It should be there. That at will disclaimer. I like to see it on pretty much every single piece of HR paper that you give to an employee. So if you're just using just that, then I completely agree with that. Do employees need to sign this form if they work for a company headquarters, a company maybe headquartered in South Carolina, but they work in another state? So if an employee works in another state, but the company is based in South Carolina, that employee is also going to be most likely subject to the employment laws of whatever state that they live in. And so you're going to be sort of, with an employee working in another state, you're going to have to comply with this and with wherever that person is living. And so the reason I highlight that is because most states have even more restrictive wage payment laws that require even more disclosures. And so you just got to be careful. You certainly want to provide at least the information contained in that form. You may have to provide even further information. And so worth checking, wherever that the state's laws of wherever that person is working. And then, should an employer have offer letters for internal candidates, transfers, promotions, etc.? That's a very good question. And yes, I would generally like to see that. The reason being that, from a wage payment standpoint, it's almost like a new job. I'm assuming that if it's a transfer, certainly if it's a promotion, there's going to be changes to the pay. And if there's going to be changes to the pay, you've got to provide them that notice in writing. And so I would just do a new offer letter, and that's what I've seen most of my clients do. There was a question about does it also include if you're increasing somebody's pay, do you still have to provide them at least 7 days notice? I would say yes. And the reason I say that is less a strict interpretation of the Wage Payment Act than just a best practice, because it's still good, even if you're not required to have some documentation about what you're paying the person. I'm probably handling 3 or 4 wage payment lawsuits right now for clients, and they all stem from, it's just not very clear in the written documentation what exactly the person was going to be paid. And so I would say, even if the person's getting an increase in pay, I'd like to see something. I'd like to see very clear sort of corporate HR documentation of that happening. Now, if you're increasing an employee's pay, the employee is obviously going to be very happy about that, and it's probably not going to call you on the 7-day requirement. But for the reasons I mentioned, I think it's still it's still a best practice. Is it acceptable to list see policy and procedural manuals on the terms of employment notice regarding vacation policy, et cetera? Yes, that would be okay, as long as it's not one of those mandatory items that's got to be on there. Then you can say, vacation, sick leave policy, discussion of other benefits such as 401k, those types of things you can say will be outlined in the employee handbook or whatever the case may be. So those are all good questions. There was, looks like, one other question, then I'll move on, about sort of yearly merit increases. If you're increasing somebody's pay sort of on an annual basis because of, or a semi-regular basis based on performance, do you have to do a new offer letter for that? I would say no, although I would, back to my point earlier, I would like to have a pretty solid paper trail with a 7 days notice notifying the employee before it actually becomes effective. But I don't think you have to actually do a new offer letter. A couple of other things in here that you might want to include in the offer letters. One thing I like to see is an acknowledgement that the employee is not bound by any non-compete or non-solicitation or anything like that that you don't know about. Most times an employee will come forward to you during the hiring process and say, hey, I've got a non-compete. But not always. And you can get in trouble potentially, for hiring somebody under one. So I like to see in there an acknowledgement that they're not bound by it. Duties and job responsibilities, a note that they're that the offer is conditional, that it's conditional on successful background check and or drug screening as applicable. We talked about specifics on compensation plans, a note about I-9 immigration paperwork also. Those are just a couple of things, back to my earlier point, why most clients sort of draft something on their own that includes that terms of employment notice, because there's a lot of other stuff that you might want to have on an offer letter. Accidental contracts, I've got at this point in the presentation, but I really already covered that when just talking about how you can, without proper disclaimers, you can accidentally find yourself waiving at will employment. So we can skip that for now and talk about formal employment contracts. I don't know, every organization is a little bit different. Most organizations have employees at the company that have formal contracts that are not at will employment contracts. Whether it's high level executives, big time sales folks, somebody you really had to lure away from another company, whatever the case may be. Oftentimes there are going to be individuals at the company that have a formal employment contract that say, this contract goes on forever unless we terminate, unless we terminate you in accordance with the contract. There's usually like cause, no cause, or, we're agreeing to hire you for a period of 5 years. And if we terminate you earlier, we got to pay out the 5 years, we got to pay out severance or something like that. These are very common. So I'll touch on them a little bit. I'm not going to talk about, business terms of contracts, but I will talk about sort of a few of the things that you need to keep in mind if you've got them. The next page just shows sort of a sample of, one that I have drafted taking out client information. This was for a veterinary practice. Most in the, and this is very industry specific, but most in the sort of medical and professional community, I mean, you're going to have an employment contract with a doctor or a vet or a dentist or, whomever. And so, I mean, this is when I talk about a formal employment agreement, this is something this is what it would look like. It's not just kind of an offer letter. It's actually something that was sat down and, very carefully drafted and signed by both parties. And sometimes in the case of higher level executives, may have been negotiated by the executive and his or her lawyer. And so I just include that as sort of an example if you're sort of losing me on a formal, when I'm talking about a formal contract. The main thing, since most formal contracts kind of do away with at-will employment, the primary thing, and when I get a call from somebody saying, hey, we need to fire somebody, okay, do they have an employment contract? Yes, they do. Send it to me. I scroll straight to termination. What are the circumstances under which the organization can fire somebody? And typically it's pretty clearly laid out. There are a few different common ways to do it. Sometimes it's, hey, if we're going to fire you for no cause or for convenience or for, it's just not working out, we'll give you 90 days notice or we'll give you 30 days notice or something like that. But if you do something bad, if you do something that gives us quote unquote cause to terminate you, and that could be a lot of different things, then we retain the right to fire you immediately. And that makes sense, right? If you've got somebody that steals money from a client, steals money from you, does something like that, you want to get them out immediately and not pay them anything further. And so, termination is really kind of the key thing there. One other thing, and I've got some examples here of a for cause provision that we can look at, just as an example of things that we typically see that would give rise to firing somebody immediately. You see the sort of first bullet point there. It's dishonesty, incompetence, embezzlement, fraud, malpractice, a guilty plea of any of that type of thing. Number two is, failure to maintain your license. Like I said, this was in the context of a veterinarian. Failure to maintain your license to practice veterinary medicine, we can fire you immediately. Any restrictions on your license, same thing. Physical abuse of a patient. A lot of what we've seen in the last few years too is provisions in here that allegations or cause to believe that sexual harassment or violation of companies' anti-discrimination and anti-harassment procedures. We see a lot of that in here. A lot of times if a cause termination is tied to violation of company policies, a lot of times what organizations will do is say, okay, if we're saying we've got cause to fire you because you didn't follow one of our policies, if you've got the ability to cure it or fix it, we're going to be required to give you 30 days notice and an opportunity to fix it before we immediately fire you. And that's pretty common as well. I'm sure some of you have seen those types of provisions in employment contracts. And you see that in that last bullet point 5 there. I would say when a client approaches me about drafting an employment agreement and they want a formal contract in place, I would say that probably 7 or 8 times out of 10, the reason for that is they want restrictive covenants in place. Maybe it's just a non-disclosure agreement, but oftentimes it's some kind of non-solicitation of employees, non-solicitation of customers, or a flat out non-compete agreement. Now, you can have a restrictive covenant agreement that's just called like a restrictive covenant agreement, or a non-compete agreement that's just called non-compete agreement. And it's not an employment agreement. It's just the non-compete in a document, and just a whole contract that just deals with the non-compete. And that's completely fine. You don't have to have one contract that's got non-compete and also has, hey, this is what we're going to pay you, and this is what your job responsibilities are. Oftentimes, though, especially with executives and stuff, it is a lot easier just to do an employment agreement and put that in there. One of the reasons being that, you often have to recite consideration for entering into these restrictive covenants, and you telling the person, hey, we're hiring you, this is what we're paying you, this is what you're doing. That helps the consideration. But also, I mean, there's other reasons to have it in one document and in one place. If you're a high-level executive that's got a restrictive covenant, you're probably going to have some for cause and not for cause language in there. You may even have that the non-compete doesn't apply if you're terminated without cause, or something like that. So also make a point here that, restrictive covenant agreements, I'm litigating a few of these cases right now. Restrictive covenant agreements could certainly be an entire presentation. We've done entire presentations on them. It's a very complex area of the law, and entering into them is not something that you could pull off the internet or grab from a friend in another company or something like that. They've got to be very, very specifically drafted for your organization, your situation, that particular employee, etc. You can kind of put templates together for your organization, but it's sort of a best practice to have, a lawyer look at it for almost every one that you enter into. So just a note on that. Most organizations have, even for employees that don't have a formal employment contract, I advise my clients that you really should have a confidentiality or a non-disclosure agreement with every single person that you hire at the organization. There's really no reason not to do it. And it's something that even with your current employees, you could probably roll out without, perhaps without providing additional consideration. Sometimes clients will put these in employee handbooks, a non-disclosure agreement, but for reasons that are beyond today's presentation, I like to see a standalone, unless you have an employment agreement. For at-will employees, I like to see a standalone confidentiality agreement an employee actually signs as a separate contract. So they're, as I say in that last bullet point, most of the time they're fairly straightforward. It's hey, the company is providing you access to proprietary business information, and in exchange for us hiring you or paying you, giving you access to this, you agree that after you leave us, you can't take it, you can't disclose it anywhere, et cetera, et cetera. Non-compete and non-solicitations are a little bit different, that they require, if you hire somebody and you enter into one, when you hire them, then that's sort of adequate consideration hiring them. But for your current employees, if you wanted to slap one of these in front of your current employees, you'd have to have separate business consideration for that. And these are the ones that have to be sort of very, very, you have to be very careful about. They got to be narrowly tailored to time and geography. You can't say that somebody can't compete or solicit your clients forever and ever like you can with confidentiality. They've got to be much more narrowly tailored to that. A non-solicitation, skipping to the next slide, you can have one of those with to prevent an employee who leaves you calling on both your customers and your current employees. Usually those are separate provisions in a contract. Non-solicitations are easier to enforce than non-competes, because we're not preventing somebody from actually going to work in their chosen field or industry. We're just saying, hey, you can go work for one of our competitors. You just can't for 2 years, which is pretty standard in South Carolina. For a period of 2 years, you can't call on all the clients you're working with and try to steal them and bring them over there, or you can't recruit our employees to come work with you over there. And South Carolina courts have said that that's, if properly drafted, that's generally fine. Non-competes, on the other hand, are much more difficult to enforce, because typically what you're saying is, when you say that somebody can't go work for a competitor for X amount of time, depending on the industry, a lot of times what you're saying is you can't work at all for 2 years or 1 year, or 18 months, or whatever you do. And so courts are much less likely to enforce non-competes. You got to have a pretty narrow geographic restriction in addition to the 1 to 2 years. And these are really, really dependent upon what the person's job role is, who the competitors are. As opposed to geographic restriction, you can list specific competitors and things like that. There's different ways you can draft it, but they're very hard to enforce. A couple of final points here. There are a few additional issues to think about when you're trying to decide, do we need to write up some kind of formal agreement? One of those is laying out what happens in the event of a dispute with your employee. And do you include an arbitration provision such that if you fire the employee and the employee files a wage payment claim against you, or a wrongful termination claim or something like that, would you rather be in arbitration rather than fighting it out in court? The answer to that depends, but in most situations, for employment claims, I prefer arbitration over court. And there's a lot of reasons for that, but entering into some kind of formal agreement would allow you to put an arbitration clause in there, and those have to be drafted very, very specifically as well. There's some other kind of legalese provisions like assignment, in the context of, if your organization is sold to another company, can you assign the employment contracts with employees? A lot of potential buyers, if you're an organization that's positioning for sale, a lot of potential buyers want to know that. Those are things that can be put in an employment contract. No oral modification clause is something that is saying, hey, this is what we agreed to in the contract. If there's any changes to this, it's got to be in writing. So you can't come back and say, yeah, I know the contract says I'm going to be paid $80,000, but we really agreed that I was going to be paid 90. A no oral modification clause is, you can't come in and say, well, we agreed to something different that's in this contract. If there's any changes to the contract, that's got to be signed in writing as an amendment by both parties. So again, there are some advantages to, even with at-will employees, for all of these reasons to having formal employment agreements in place. And as I mentioned, somebody put in a good question before the webinar today about repayment agreements and moving expenses, tuition repayment plans. I've drafted a lot of those for clients that send their employees to pay for them to get additional training or certification, or even, to go to business school or whatever the case may be. Always need a contract for those situations. I've got a conclusion here, which is just a couple of final parting thoughts. One other thing I do want to mention, and I kind of made reference to this at the beginning, is there's only two classifications for workers. You're either a W-2 employee or you're a 1099 independent contractor. A lot of organizations hire contractors as 1099s. I recommend that every single contractor, unless it's a super small little one-off thing, that you have an actual independent contractor agreement in place with 1099 workers. There are a lot of risks in hiring 1099 workers that the IRS or the Department of Labor are going to say that they're misclassified and they really should be W-2 employees. And I mean, your best way to fight against those claims is going to be to have an independent contractor agreement in place. Again, beyond the scope of today's conversation, but just something to keep in mind, because we've been talking about W-2 workers this entire time today. So I put this last slide here as sort of a way to try to, I guess, distill all this information and try to help you as HR to come up with a strategy of what we're going to do. And so let's start at the bottom, and this would be for, I mean, every worker at the company, regardless of what their level is, whether it's C-suite or whether it's, your hourly lowest paid worker, as I mentioned earlier, that they should probably have a confidentiality agreement in place. And so as a general rule, what I like to see for kind of entry-level positions is, an offer letter and a confidentiality agreement. That would be kind of a general good rule of thumb to go by. For your mid-level management, it's probably an offer letter. It's either an offer letter and a confidentiality agreement, or maybe you want to have an actual restrictive covenant agreement in place. Maybe it's a non-solicitation of clients. Maybe it's an actual non-compete, something like that. But you probably want to consider that for kind of your mid-levels. And you can do an employment agreement at this level as well. I mean, if you're going to say, hey, we're going to do a restrictive covenant agreement, I might say, well, let's just do an at-will employment agreement and sort of combine, the offer letter and the restrictive covenant agreement into one. And then for your key employees, your people that are really, really critical to the organization, those are workers that probably need a formal contract. At the very least, I would think a restrictive covenant agreement. So some organizations are weird about having things that they call employment agreements. At the very least, having a restrictive covenant agreement, probably a formal contract, especially for C-suite folks. I mean, if you're going out and hiring a new COO or a CFO or something like that, I mean, the candidates they probably had an employment agreement at their last job, and they are probably going to expect the same type of thing with, cause provisions and notice before getting fired, and maybe built-in separation payments if they're fired without cause and things like that. So that's just kind of one way to think about it. There's no magic to it, but that's sort of a little bit of a hierarchy of ways to think about these contracts with employees. That's pretty much it for the presentation. I've got a couple of minutes here before 1 o'clock that I'm happy to answer any questions if anybody wants to put any more in the Q&A. And while we're giving everybody an opportunity to do that, if they want to, just a announcement about 2 upcoming seminars that we've got on October 27th. My colleagues Katie Busby and Chris Gant Sorensen are going to be talking about the Americans with Disabilities Act and technology. The whole technology and HR conversation is starting to get really interesting. I saw something from the EEOC about artificial intelligence being used for hiring and technology used as surveillance for workers that are working remotely, tracking their productivity, monitoring what they're doing every second that they're on their laptop at home, those types of things. And then on November 17th, Demetrius is going to talk about the onboarding process for new hires and establishing culture and how to assist with retention efforts. And I think that'll be really cool. And that, it's sometimes these ones, like the one today, was probably a little bit too much legalese in the one today, but I think that one will be a really good HR discussion with some legal mixed in. So please join us for those 2, and thanks to those of you in the chat that are putting in nice things about the presentation. We appreciate everybody joining us, and of course y'all know how to reach me if you've got questions. So hope everybody has a good rest of the day, and don't get underwater with all this rain. Stay safe out there.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.